Welcome to the video segment on paternity. My name is April Green. I'm the directing attorney at the Legal Aid Center of Southern Nevada in Las Vegas. And I am going to be talking to you about establishing paternity and some of the law concerning paternity. What I'm going to tell you is just basic information on establishing paternity in the state of Nevada, how to do it, how to commence a case, and some of the basic bullet points of law. The law can be found in Chapter 126 of the Nevada Revised Statutes. And before we get started, I want to say that this information, this legal information, is not intended to replace an attorney. You can get a free consultation with an attorney in Las Vegas at a program called Ask a Lawyer. And the sessions are held at Family Court, which is located at 601 North Pecos Road in Las Vegas, Nevada, 89101. You can call the Legal Aid Center at area code 702-386-1070 and follow the prompts for Ask a Lawyer in order to talk about your case and to get more specific information regarding your own particular situation. So having said that, we'll get started. In Nevada and probably in many other states, there are certain what we call presumptions regarding paternity, meaning under the law, these things will be presumed. Number one, if you are married to a person when a child is conceived or within 285 days of the termination of a marriage, the man is presumed to be the father of the child. Also, if the parties live together at least 6 months prior to the conception of the child and continued to live together after the child was conceived, it will be presumed under the law that the man is the father of the child. Also, if the parties attempted to marry each other, there's a good possibility that the man will be presumed to be the father in that situation. To get into the numbers and the particulars on that, again, direct yourself to Chapter 126 of the Nevada Revised Statutes. Also, if a man accepts a child into his home and then openly represents himself as the father of the child, that man will be presumed to be the father of the child. And those are the four basic presumptions regarding paternity. And what a person, how this plays out is that if you want to start a case to establish paternity, in the complaint, you will have to identify how paternity is established or should be established as far as you're concerned. And what you would do would be to write in the applicable presumption. Another very basic presumption is one that happens after genetic or DNA blood testing. If a person submits to DNA testing and there is a positive result, then that man is presumed to be the father, and a positive result could be 99.99% of probability that a person is the father. If you get that kind of positive testing, that man will be presumed to be the father as well. And any of these presumptions can be rebutted by clear and convincing evidence to the court. There are also certain presumptions regarding custody that you will find in the parentage law in Chapter 126 of the Nevada Revised Statutes. And the first one is that the mother is presumed to have custody of a child if the child is born out of wedlock in the state of Nevada. However, if the mother abandons the child to the father and the father goes on to provide the care and control and has physical custody of the child, then the father is presumed to have custody of the child. So just keep those two things in mind. Now, we know at this point that under certain circumstances, paternity will be presumed. But if you actually want to establish paternity legally and to be able to get that in writing, then there are about 4 ways to get that done. The first way, and probably the most common way, would be to simply admit paternity. And that's something that can be done usually when the child is born. At the hospital, certain forms are presented to the mother and father there at the hospital if the father is present. And the father can simply sign a document called affidavit of paternity. And by signing that, and this assumes that the mother consents and says, yes, this person is the father, that will establish the paternity of the father. And that form can also be signed by the father within 30 days of the birth. The father should just follow up with the hospital or the state of Nevada Office of Vital Records for the appropriate forms to admit paternity. The father can also try to disestablish or rather revoke the admission of paternity by completing the appropriate forms within 60 days of the birth, and the father should follow up with the hospital or the Bureau of Vital Records if the father comes to believe within the set amount of time that he is not the father of the child. These admissions of paternity can be challenged by the mother in court at a later point, or by the father if you happen to miss the deadline to revoke it through the forms. Also, the district attorney child support division is a place where a person can establish paternity. The district attorney child support division, the office is located at 1900 East Flamingo Road, Suite 100 in Las Vegas, Nevada. And a person can contact the district attorney's office to commence a case and complete the appropriate forms to take the first step, which will be DNA blood testing. And if the testing results in a positive 99.9 result, then paternity can be established through those kinds of cases. But of course, if the father does not have care and control of the child, in doing so, the father will be liable for support for the child, and the DA will go on to commence a child support case against the father of the child. If the father, on the other hand, does have care and control of the child and the parties are not married, the DA can also go after the mother of the child for child support. So that's primarily what they do, is commence actions or enforce court orders to obtain child support for people responsible for a child. I should say at this point also that that each parent, the mother, the father, and the child have a right to have a relationship with their parent or with their child, as the case may be. And establishing paternity is the beginning of having those rights acknowledged by the court and by any and all third parties. Okay, so we're talking about establishing paternity, how to go about doing that. We've said that the father can admit it at the hospital or within a certain amount of period after the child's birth. Either party can go to the district attorney's office to commence a case. And by the way, the district attorney can commence a case as a result of a welfare contact if one of the parties is on welfare for the benefit of the child. The DA can commence an action for child support against one or both of the parties to collect child support for the benefit of welfare. That's something that happens very frequently. Another way that paternity can be established is through the commencement of a court case through family court here in Las Vegas. The family court is located at 601 North Pecos Road in Las Vegas. zip code 89101. The family court has a self-help center, and at the self-help center, either party who wishes to establish paternity can either purchase the forms to start a court case, or the forms can be downloaded by obtaining the website information at the self-help center. And what a person does is you get the package, there's certain forms that start the case out, you complete the forms and file them with the court, follow the case through, and if things go the way you want them to go, you'll wind up with a court order that establishes you as the father of a child. I should say that the forms that are sold at the self-help center, the complaint says complaint to establish paternity, custody, visitation, and child support. Because most of the time, if a person wants to establish paternity, once that is done, they go on to get custody rights and visitation rights and have the court to make court orders on all those things. Now, there are rare cases where a person only wants to establish paternity. They don't want to go on and establish custody and visitation and child support. And what you would have to do is to only complete the sections that pertain to paternity. When you get to the other sections for custody, visitation, support, medical insurance, and so forth for the child, you would have to write in NA. You shouldn't leave any of the lines blank. NA, and the law clerk and the people at the court will figure out that you're only trying to establish paternity. I had one case once where that was the case, and the reason was because the parties were still living together, but the father wanted to provide health insurance for the child, and to do that, the paternity had to be established, and he decided to do it in that way. So there are cases where people want to do paternity only, and that's the proper way to do it. If an attorney were involved with the case, or if somebody were to type up the complaint to establish paternity and not use the self-help center forms, then you simply would not add any provisions for custody, visitation, or support, or medical insurance. You would only request to the court to establish paternity. You would say what the basis is, whether there is a presumption in place which should establish your paternity. You will give the facts that helps you establish that the presumption is in effect in your case, and file your pleadings. The other way that paternity could be established to a certain extent is by just taking the child, the father and the child, going to a licensed laboratory and submitting to blood testing or a cheek swab or whatever the lab uses to establish the DNA favorabilities or the DNA likelihood between the father and the child, and they will give you a report saying whether the paternity was established by 99.99 or that it was negative, and that the likelihood is that the person is not the father. If you get such a lab report, I mean, there may be entities that may accept it to disestablish paternity, but it wouldn't have the strength of a court order. But that is a way to at least find out whether a child belongs to a person or not. It does cost a lot more to go directly to a lab without a court order than it does to go with a court order. If a person starts a case to establish paternity and they're not sure whether they are the father or not, the first thing they have to do is ask for paternity testing, and the court can give a person a slip to go to a lab where the testing can be done. The court can order the other parent to cooperate with the testing, to allow the child to go with the father to get swabbed or get blood taken so that the results can be known. And along those lines, if a case is started to establish paternity, whether it's with the custody or not, and the results, or the person goes to a lab and the results are negative, then that is presumed to be the end of the case if a court case was commenced. Once the results are negative and the person is not the father and they were not named as the father on the child's birth record, then that's pretty much the end of the case. The person will not be legally established to be the father, and that will be the end of it. But let's say, again, you want to establish paternity, you commence a case. The forms you will need will be the family court cover sheet. You will need a declaration regarding jurisdiction. You'd have to state for the court where the child has lived for the past 5 years, or if the child is less than 5 years old, where the child has lived since birth. A person would have to complete the complaint to establish paternity and fill out all sections, particularly if you want to also establish custody, visitation, child support, and provisions for medical insurance. And there is also an optional form called a joint preliminary injunction, which a person can complete to stop the other person from harassing you while the case is going, or from removing the child from the jurisdiction without your permission or the court's permission. Those 4 forms and the summons is another form that has to be completed, will start the case. So actually there are 5 forms. You complete those forms, you file them with the court clerk. There is a fee to start the case, and if you do not have the money to pay the court fees, you should also complete the forms for informa pauperis. You can get those forms from the Self-Help Center. Those are fee waiver forms, and in some circumstances, if the person is without funds and those forms that you complete back that up, your court fees can be waived. So those forms can take the place of money, but you have to follow and make sure that the court actually waived your fees, because if they don't, then your complaint will not get a case number, and it will not be considered to have been filed. So let's say you file the case, you get a case number. The next thing you have to do is to serve the other party with the paperwork. And assuming that the person is served, you then follow up to file an affidavit with the court to show that the person was served. You yourself cannot complete that affidavit of service, and you cannot serve the party. A person other than yourself who's over 18 years of age and not interested in the case can serve the papers on the other side, or you can hire a licensed process server to do so, or contact the constable's office, or the marshal's office, or perhaps even Metro, under some limited circumstances, can serve papers on the other side. But once those papers are served, the person who served the papers needs to complete an affidavit of service, and that needs to be filed with the court. And from that point, the other party has 20 days to answer. And if they don't answer the papers within 20 days, then you can file a document called default and then go on to finish your case. And you will get what you asked for, assuming that the paperwork that you completed is correct. The persons who may start the case are either parent or an interested third party, such as the district attorney. And those are the basics in terms of commencing an action to establish paternity in the state of Nevada. And if you need further information on this subject, you can always go to Ask a Lawyer, which I mentioned before. And you can also apply to the Legal Aid Center of Southern Nevada for representation. There are income guidelines. You can go to lacsn.org for our income guidelines, and apply for representation for someone to represent you in your paternity action. I hope this information was helpful to you, and good luck with your case. Thank you.